Okay, it's 2 past, so let's get started. Welcome to everyone who has dropped into the webinar today, running live. I'm Dr. Melanie O'Brien, President of the International Association of Genocide Scholars, and I would like to welcome you to our webinar today that is celebrating the commemoration of the 75th anniversary, which is this month, of the 1948 Genocide Convention. Now, the Genocide Convention is, of course, such an important piece of international law for genocide scholars. It's the base that we pretty much all start with when we're talking about genocide. And of course, we always do make much reference to Raphael Lemkin, who is the Polish jurist who coined the term genocide and was the key person behind the drafting of the Genocide Convention in 1948. His own experiences stemmed from having seen what happened in the news during the Armenian genocide and also his own personal family experiences during the Holocaust. He started to think about why we have a crime for one person killing one other person, but we don't have a crime for the killing of thousands or even millions of people. And that's how he created the word genocide. And he then went on after the Holocaust, after World War II, to push for the creation of the Genocide Convention. He was very dogged in the work that he put in for that, running around in New York and pressuring all the states to put something together, and he was ultimately successful. Now, while the definition that ended up in the convention wasn't the same as the definition that Lemkin himself had come up with in his writings, it was, like all international law is, a compromise. It's still a really, really important piece of international law. The Genocide Convention obligates countries that are a state party to that convention to prevent and punish genocide. But the contents of the convention itself are quite simple, and so there has had to be a lot of evolution from the Genocide Convention in places such as domestic courts and international courts. And today we're going to hear from 5 speakers who are all members of the International Association of Genocide Scholars to talk about what the legacy of the Genocide Convention is today, 75 years after its creation. So I'd like to introduce our first speaker today, who is Dr. William Pruitt. Dr. Pruitt is Assistant Professor of Criminal Justice at Austin Peay State University in Tennessee in the USA. Dr. Pruitt holds a JD from Syracuse University College of Law with specialization in family law and social policy. He also holds a PhD in criminology and public policy from Northeastern University. He has served elsewhere in various capacities at Lemoyne College, Endicott College, and Virginia Wesleyan University. His research interests include genocide, crimes against humanity, and the legal response to mass atrocity crimes. He has published about the theoretical aspects of genocide, as well as the criminal sanctions imposed by international tribunals. Dr. Pruitt has published a textbook on the criminology of genocide, as well as many articles dealing with genocide, genocide denial, and legal outcomes at international courts. And it's my pleasure today to introduce Dr. Pruitt as our first speaker for this panel, and he will be speaking on flawed perfection, the flawed definition of genocide. Dr. Pruitt, the floor is yours.
Great, thank you so much. Thank you for having me. I'm just going to share my screen with everyone. Great. As was mentioned, I am Dr. William Pruitt from Austin Peay State University. My background is in criminology and law. So when I was, first read about the call for abstracts on the legacy of the Genocide Convention, my first thought went to the definition of the crime of genocide. As legal and criminologists, often point out, we have to have a definition before we can have a prosecution or anything else. Many different fields of study have their own definition of genocide. Psychology, anthropology, history, political science, sociology, they all have these common definitions, but only one of which have we used to prosecute the crime, as a international offense. And as we've seen in other cases, when we look at the definition of genocide, we often have debates over whether something is technically genocide, and that can hinder prevention. When do we apply the UN Convention? How do we know if something is genocide? Well, again, the definition is helpful because it becomes part of identifying, responding, and punishing the resulting atrocities. And defining an activity helps one understand it better. That's why we have definitions. As was mentioned, of course, Raphael Lemkin is our founding, father here, and he defined genocide in a much broader way than we legally do so. Right? His idea was that a coordinated plan of different actions aiming at the destruction of essential foundations of the life of national groups with the aim of annihilating the group themselves. So it can be directed at individuals, but the broader purpose is to eliminate the entire group. And that was really the focus of Lemkin as he wrote his work on genocide. But as we mentioned earlier, the UN Convention, of course, is a compromise. And the official legal definition is what the UN Convention has given us for the past 75 years. And it is, again, the very specific crime of any of the following acts committed with intent to destroy. And intent becomes really important in the criminal law, right? What is your intent? And it's a specific intent crime here. To destroy in whole or in part a national, ethnical, racial, or religious group. And then we have the several different ways of which it could occur. The reason this has been so important is because it's the official legal definition, and it's become the one that has been adopted by most states in their domestic genocide legislation. It certainly has been used by international courts like the ICTY and ICTR to prosecute individuals for the crime of genocide, but it's not perfect, right? It's been attacked as weak for excluding certain groups. It's been attacked as having perhaps too strict of an intent requirement, and it has other flaws. But again, it's a compromise that we've lived with for 75 years, although we could ask whether it's time to update it. In social science definitions of genocide, you see a little bit more broadening of the term. Chalk was talking about the idea that you can't ignore genocide of social groups and political groups because then we give up the ability to understand genocide in its entirety, right? So he said the UN definition ignored too many episodes of genocide. And he offered his own definition, which was a form of one-sided mass killing in which a state or other authority intends to destroy a group, as that group and membership in it are defined by the perpetrators. So this allowed for much broader coverage of than the UN definition. It was a little closer to Lemkin's definition, though it still has its own interesting side effects of one-sided. A state or other authority intends to destroy a group. There is still an intent element. A definition by itself is limiting, right? A limited definition of genocide places restrictions on what can be called genocide. But a broad definition has no limits and provides no guidance. So we can't have no guidance. We have to have some definition. Shaw offered a definition of genocide as a form of violent social conflict or war between armed power organizations that aim to destroy civilian social groups and those groups and other actors who resist this destruction. That's a little broader. It's a little less defined. It's a little less broader encompassing, but less definitive over who's being protected. And obviously, without any limits, any action could be labeled genocide, and it diminishes the impact of the word and the deed. Helen Fine was looking at the UN definition and offered a kind of an addition to it. She said, it's an okay definition, but it's missing certain things. So she offered a definition that was a little bit broader and said, sustained purposeful action by a perpetrator to physically destroy a collectivity, directly or indirectly, through interdiction of the biological and social reproduction of group members, sustained regardless of the surrender or lack of threat offered by the victim. So it mirrored the UN definition, but expanded it slightly to cover more atrocities. This is also what Leo Cooper did in his founding document on genocide. He accepted the UN definition, but added political groups and highlighted a nexus between genocide and war. So he was willing to accept the UN definition, but as arguing that it had to have a little bit more additional coverage to it. So again, accepting the definition as it is, or at least accepting it to an extent. So the legacy of the United Nations definition in the convention is that, it's the most recognizable legal definition of genocide over time. It's lasted, as we said, 75 years. It's been used in multiple prosecutions, both domestic and international. To be a legacy or to have a legacy is to be a long-lasting impact or to have a long-lasting impact. Well, there's no doubt that this definition in the UN Convention has had that long-lasting impact, both on prosecution and intervention. Again, it's flawed, it's not perfect, it's the result of compromise, but it's been used and reused for several times or for multiple times across legal doctrines and legal courtrooms. So for that reason alone, I think that's why I think of the definition of genocide when I think of the legacy of the convention. It has been around for 75 years, and it's probably going to be around for another 75 years because the convention is not looking to be rewritten anytime soon. And we have to accept that this is the legal definition of genocide, and we still have to honor those victims who fall outside of genocide and explore their persecutions and understanding, but at the same time recognize that we are living with the definition of genocide that has been around for 75 years. And I think that's why I think of the definition when I think of the legacy of the UN Convention. Thank you so much.
Thank you so much, Bill. Wonderful job keeping to time there. I was almost not prepared. Thank you so much. And I think that was a great, essentially introductory piece as well about the legacy of the convention and the definition of genocide for us to move into the rest of the presentations. Our next presenter is Dr. Kerri Malloy. Dr. Kerri Malloy is an assistant professor of Native American and Indigenous Studies at San Jose State University in the USA, specializing in Indigenous and genocide studies. His research focuses on the genocide of Indigenous peoples and the ongoing healing and reconciliation in North America. Dr. Malloy looks at the need for systemic change in social structures and the promotion of transitional justice in response to human rights violations through judicial and political reform. And Dr. Malloy also currently serves on the IAGS Advisory Board. And it's my pleasure to hand over to Dr. Malloy, who will talk about past lessons, revisionist history, and determination of intent. Kerri, the floor is yours.
Thank you very much, Mel. And good morning, good afternoon, good evening to wherever you happen to be. I'm coming to you from the extreme parts of Northern California in the United States and the homeland of the Wiyot people. This is where I reside most of the year when I'm not in San Jose, and it's also close to my homelands, which are north of here along the Klamath River. When thinking about the legacy of the definition and the convention, it gets complicated from the perspective of Native American Indigenous studies, because we're talking about the past. We're talking about things that occurred prior to 1948 to the formalization of the definition. And when you're teaching a class and you're talking to them about what occurred in the Western Hemisphere, what occurred around the world during the Age of Exploration, to the buildup of these nation states, the question students will ask you the most often is, was it genocide? And the simple answer is yes, no, possibly, maybe. Because we have to get down to that cornerstone of intent. What was going on? Was this actually the intent of extermination? Was this a clash of cultures? And there's a large debate both within Native American studies and Indigenous studies around the world and throughout academia, what really happened. And that's a debate that we need to have. The convention gives us a tool. And, we hear a lot about the legal definition and how it's not perfect, it needs work. That's okay. When we're looking backwards, if we use it as a tool and we begin to frame things and looking at the definition, and then identifying those specific instances that meet those criteria of Article 2, it helps us begin to build a larger case. And it means that we have to do something a little different than we've done in the past. We have to move away from the large hegemonic understanding of indigenous genocide. And we have to move to a very localized discussion of it and understand that by placing it in this massive context of indigenous genocide, we are erasing the individual identities of individual tribal nations and groups. So we have to localize this into a regional level. And using the convention allows us to do that and to look at not a genocide of indigenous people, but a genocide of Aztecs, of Mayans, of Maori, of Torres Islanders, Yuroks, Karuks, Cherokees, and look at a very tribal national unit level, and then determine what really happened and lay that out in a framework that we can then begin to also look at. Not only do we meet the definition, were the criteria that we use, the most common cited risk factors that we use in genocide prevention, also present? And then laying those together to give us a better understanding of what happened. When you're dealing with communities that are in conflict, that have a history of mass atrocity and genocide, there's always the pointing of fingers, the blame, who did what, when, and the I wasn't there, so how can I be responsible for this? By using the convention's definition and laying it back, we can show that these occurred, and it's not anyone today's fault or responsibility for what happened, but it is our responsibility to know, and we can begin to open a larger dialogue on that. As we've seen in Canada with the report on the missing, murdered Indigenous women and girls, they use their own domestic definition of genocide to determine if what was really happening to the Indigenous people there qualifies as genocide, and they determined that it did. It allows us to begin to use definition and the law to frame things that we can then communicate in a non-legal manner, in a language that everyone can understand, to begin having open discussion and conversation around what does this mean to move forward. But it also gives us an interesting ability to use the perpetrator's own language. The language in the definition, the language in the convention, was not crafted by the victims, or particularly the Indigenous victims of genocide. It was crafted by the settler states and agreed to by those same states, that this was the crime that they may possibly have committed without thinking about it. So we can use at this point the language and understanding of genocide from the perpetrator standpoint to frame the actions of the past to help us begin to move forward in the future. I have my students engage with a mental exercise a lot, and I ask them to think about that time when they were little kids, whether they were hanging out with a sibling, a cousin, a best friend, and they got into a squabble, and one of them did something to the other. Probably hit them, took their toy. Anyway, somebody broke down crying. And a parental unit stepped in and told the kid who was responsible, or they thought was responsible, to apologize, to say, I'm sorry. And they did it. They didn't mean it. The person they apologized to, and you may remember this from your childhood, you still remember who apologized to you and didn't mean it. You still hold it against them, and that's okay. But how do we get past that? How do we move through that? And the legacy of the convention allows us to take a framework and look at the past, what happened, and determine really, like, this is intent. This was genocide. This is why we have the social division in the world that we do, and we need to address that at a larger scale. And until we move past just the, okay, yeah, it happened, great, we're going to continue to have that. And what the legacy of the convention does is not only gives us a framework, but gives us a path to begin to address the larger complications of that social division, which is perpetuating genocide, perpetuating mass atrocities, perpetuating racial division, and look at it from a different standpoint of not necessarily is it or was it, but how do now we move forward and beyond? And when I tell my students that the answer is simple, yes, no, possibly, maybe, they all look at me and going, that's not simple, that's complex. And I said, well, that's because nothing is simple. And we have to look at each instant and then frame it within that larger framework and understand how that impacts us today and what that legacy of those events are and how the criteria laid out in the convention has been used by scholars to look at Indigenous genocide, look at the genocides that are going on, to understand really what is happening and put in a framework that all of us can understand. And that, to me, is the legacy of the definition. Thank you very much.
Thank you so much, Kerri. I think it's really important. Sometimes we forget how big genocide is, and we forget that there are elements of that process, whatever stage of the process, that are connected to everyday things like the apologies that you were just talking about, and how important those things are in general life every day. I'd like to introduce our next speaker, who is one of our two speakers that's going to be focusing on different international courts and tribunals. Dr. Narelle Fletcher is a lecturer in International Francophone Studies at the University of Technology, Sydney, and I would like to particularly thank Narelle for joining us at what is really quite an unpleasant time for her there in Sydney. Narelle's research focuses on the 1994 genocide against the Tutsi, more particularly the language used to speak of the genocide in Kinyarwanda, French and English. Dr. Fletcher's latest publication is a book chapter exploring the lexical and rhetorical strategies of genocide denial in Rwanda. She has previously published articles examining the socio-linguistic challenges of prosecuting rape as genocide at the ICTR, the 1992 inflammatory speech by Rwandan politician Léon Mugesera, and the connotations of the terminology used by successive French governments in relation to the genocide in Rwanda. Dr. Fletcher will be speaking today about the Genocide Convention and the Akayesu trial at the International Criminal Tribunal for Rwanda. Narelle, the floor is yours.
Thank you very much, Mel. I'll just share my screen. We go. So as we commemorate the 75th anniversary of the Genocide Convention, today I'll be examining the relationship between the Genocide Convention and the trial of Rwandan Mayor Jean-Paul Akayesu at the International Criminal Tribunal for Rwanda. This was the first case to be brought before the tribunal, with proceedings beginning on the 9th of January 1997. The tribunal's judgment and sentencing that was handed down on the 2nd of December 1998 was a landmark for international justice, as it constituted the first conviction for the crime of genocide since the official definition of that term in the 1948 Genocide Convention, some 50 years earlier. My discussion today will firstly examine the importance of the Genocide Convention for the genocide in Rwanda and the ICTR, and then conversely the significance of the Akayesu trial for the Genocide Convention. As the genocide targeting the Tutsi in Rwanda was being carried out between April and July 1994, the issue of whether this concerted aggression should be formally recognised as a genocide constituted a highly contentious question for the international community. The key sticking point was directly related to the Genocide Convention. For both the UN and the US, it was believed that official acknowledgement that the events in Rwanda constituted a genocide would necessarily carry an obligation to intervene. Within the UN, care was taken to describe the events in Rwanda using a far more nebulous range of terms, such as chaos and indiscriminate violence. In the US, government officials used the tactic of deflecting the focus of the discussion to a question of semantics. State Department spokesperson Christine Shelley stated in response to a reporter's question, "Well, as I think you know, the use of the term genocide has a very precise legal meaning. Before we begin to use the term, we have to know as much as possible about the facts of the situation." However, as Gregory Stanton has elucidated in an article exploring whether the genocide in Rwanda could have been prevented, the belief that a response was mandatory is in fact an erroneous reading of the wording of the convention. Article 8 specifies that any contracting party may, not must, call upon the competent organs of the United Nations to take action. Another pertinent and interesting perspective on the international community's reticence to use the G word in relation to Rwanda is provided by General Romeo Dallaire, who led the UN peacekeeping mission in Rwanda during the genocide. In an interview he gave some 10 years later, Dallaire commented that for Westerners, the term genocide refers to the Holocaust. The idea of a new genocide was inconceivable. Beyond the question of whether the official use of the term carried any sense of a legal obligation to act, the semantic assimilation of the terms genocide and Holocaust meant that any new conflict classified as a genocide intrinsically carried the heavy moral imperative to intervene, to uphold the mantra of never again. These broader connotations can therefore also be seen as a significant factor in the official policy of avoidance of the term genocide within both the UN and the US administration. The core motivation for the creation of the term genocide by Raphael Lemkin, as we've heard, and for the Genocide Convention was to combat the impunity hitherto enjoyed by those responsible for that crime. The Genocide Convention was a seminal document for the judicial proceedings at the ICTR, as it provided the definitional framework for the successful prosecution of the crime of genocide. I would also argue that for the international community, it continued to embody a moral imperative to act in the face of compelling evidence that genocide had been committed in Rwanda. If it was too late for prevention, it was certainly not too late for prosecution. Jean-Paul Akayesu was a mayor in the central Rwandan municipality of Taba at the time of the genocide. He was initially indicted on 12 counts of genocide, crimes against humanity, and violations of Common Article 3 of the Genocide Convention. 3 further charges relating to rape and sexual violence were approved, and an amended indictment was issued on the 17th of June 1997. A significant feature of the Akayesu case was that almost every legal question had to be decided with no precedents. However, once those decisions had been made, they themselves provided valuable precedents for subsequent ICTR courtroom practices and judgments. In this connection, Chief Prosecutor Pierre-Richard Prosper commented at the time that the Akayesu trial gives us a roadmap of how we are to proceed. The majority of witnesses testifying at the ICTR expressed themselves in the national language of Rwanda, Kinyarwanda. The difficulty in translating the Kinyarwanda terminology used in the testimonies was one of the biggest challenges encountered in the Akayesu trial, as it was imperative to provide adequate proof of definitive causation between the act characterized as incitement or provocation in this case and a specific offence. In this connection, the Akayesu case was also significant in its recognition of the importance of understanding the Rwandan cultural and linguistic context in order to accurately decode the witness testimonies. The judgment of 2nd of September 1998 explicitly acknowledges that in this regard, it had relied substantially on the lexical and sociocultural insights of Rwandan linguist Mathias Ruzindana. The Akayesu ruling set an important precedent for all of the subsequent trials at the ICTR in terms of the evidence it would deem as adequate as proof of incitement to genocide. Since it was the first trial conducted at the ICTR, it was the prosecution's responsibility to not only establish the individual guilt of the accused party, Akayesu, but also to prove that a genocide had been perpetrated in Rwanda in 1994. This was a crucial element, as one of the core arguments of Akayesu's defence team was that adequate evidence had not been provided that a genocide had taken place. By officially deeming that the events taking place in Rwanda between the 6th of April and 17th of July 1994 constituted genocide, the Akayesu trial effectively broadened the parameters of the understanding of the term genocide beyond its restrictive identification with the Holocaust that has been previously mentioned. It can also be seen as a valuable point of reference in terms of combating genocide denial. The Akayesu trial also made significant contributions to international law and the interpretation of the Genocide Convention. For example, it undertook a detailed examination of what constitutes the target victim groups identified by the Convention. In the pursuit of an objective definition of those groups, this in turn has sparked further robust debate, particularly as the understanding of some of the terms such as racial group have evolved considerably since the 1948 Convention. However, arguably the most famous contribution of the Akayesu trial was its successful prosecution of sexual violence and rape as crimes of genocide. As the UN Division for the Advancement of Women commented on Akayesu's judgment, in making rape part of the perpetrator's conviction of genocide, the tribunal has advanced the world treatment of rape and sexual violence and begun the long process of reversing the climate of impunity that sexual crimes in wars had enjoyed. Writing on the occasion of the 50th anniversary of the Genocide Convention in 1998, legal scholar William Shabas commented that for a time it was the forgotten convention, drafted in the aftermath of the Holocaust, but then relegated to obscurity. For Shabas, the events in Rwanda and Bosnia rehabilitated the convention, endowing it with both currency and urgency. His conclusion, particularly in relation to Rwanda, was that the prevention of genocide was the Convention's great failure. Some 25 years later, as we commemorate the 75th anniversary of the Genocide Convention, landmark cases such as the Akayesu trial can attest to how much has been achieved in the fight against genocide and impunity, but also point to how much effort, goodwill, and courage is still required to achieve the goal of prevention. Thank you.
Thank you so much, Narelle. I think it's really important to see this relationship between what has the Genocide Convention given international tribunals and what have they given back to the Genocide Convention. And of course, we can't forget that the Genocide Convention actually has a provision in there that allows for the prosecution of genocide in international criminal courts and tribunals. So that relationship is quite significant. Bearing that in mind, now we've heard about the ICTR, I would like to introduce our next speaker, Mr. Mohammad Pizuar Hossain, who is a senior lecturer in law at East West University in Bangladesh. He was a consultant at the Bangladesh Office of Asia Justice and Rights in Indonesia in the past. He has also been a Chevening Scholar, under which he undertook his master's at the University of Edinburgh in Scotland. Mr. Hossain is an accomplished researcher whose recent academic outputs have been published in esteemed journals such as Holocaust and Genocide Studies and the International Journal of Human Rights. His research interests lie at the crossroads of international law, criminology, human rights, and genocide studies. As a principal researcher, he has led 2 funded research projects on Myanmar's Rohingya genocide. Mr. Hossain also contributed data on international criminal justice in Bangladesh to the European Cooperation in Science and Technology Action. And of course, Mr. Hossain currently also serves as a member of the IAGS Advisory Board. We'll be moving from the ICTR to the International Criminal Court, and Mr. Hossain will be speaking on evaluating the International Criminal Court's response to genocide, a focus on the Al-Bashir case. Pizuar, the floor is yours.
Thanks, Mel. Let me share this slide. All right. So good morning, everyone. It's very early morning in Bangladesh now. So on the occasion of 75th anniversary of the Genocide Convention, I thought it's worth evaluating the role of International Criminal Court in combating genocide. So if you look into the title of my presentation, it's Evaluating the International Criminal Court's Response to Genocide, a focus on the Al-Bashir case. In my presentation, I'll try to make a bridge of the International Criminal Court and the Genocide Convention. In the introduction, I will not repeat the definition of Genocide Convention because the first speaker, Dr. Pruitt, has elaborately explained the Genocide Convention's definition of genocide. But if we look into the Rome Statute, its Article 6 has exactly the same definition of genocide that has been adopted from the Genocide Convention. The International Criminal Court, as I said, that I will be talking about its role in responding to genocide judicially and the Al-Bashir case involving genocide charges. In my presentation, I'll explain why I've focused on Al-Bashir case because this is one of the cases in the ICC which has genocide counts. I think this is the only case which has ICC counts in the ICC so far. Now, moving on to the ICC's effectiveness in combating genocide. I've actually focused on two tools in my paper. One is preventing genocide, and the another one is punishing genocide. If we look into Article 1 of the Genocide Convention, it says two objectives of the Genocide Convention. One is to prevent genocide and to punish genocide. So to evaluate the role of international criminal courts, effectiveness in combating genocide, I've used these two tools to see whether ICC has played a role in breaking genocide-causing cycles of violence, and whether ICC has enhanced the likelihood of genocide prosecution. Now, before I move on to the discussion of my paper, let me show you the chart where you can see the member states of the Rome Statute which did not sign the Genocide Convention. I think it's important to see because some of the states are parties to the Rome Statute, but they are not parties to the Genocide Convention. At the same time, there are state parties which are state parties to the Genocide Convention, but not to the Rome Statute. But how this, Rome Statute and Genocide Convention can play a role in preventing genocide, and how the state parties of one of these conventions can play a role in preventing or punishing genocide, this is really important to know. And that's what I'll try to explore in my research. Moving on to the first point that is related to breaking genocide-causing cycles of violence. Regarding allegations of genocide, ICC so far formally charged Sudanese President Al-Bashir with 3 counts of genocide in Darfur. ICC's involvement in the situation of Darfur, including a request of arrest warrant against Al-Bashir, provoked a diverse kind of reactions. For example, some of the African states have raised their voice saying that they will withdraw from the Rome Statute. Apart from that, there were some other reactions as well after the arrest warrant was issued against Al-Bashir for causing genocide, crimes against humanity, and war crimes in Darfur, Sudan. In my paper, I did not talk much about Myanmar's Rohingya situation and the ICC's rule, but I think it's important to remember that ICC has, issued a rule for this crime against Rohingya in Myanmar, not as genocide, but as crimes against humanity by forcible deportation from Myanmar to Bangladesh. Here, Myanmar is a party to the Genocide Convention. Bangladesh is a party to both the Genocide Convention and the Rome Statute. I think it's important to know because right now there is a genocide trial ongoing in the International Court of Justice brought by the Gambia against Myanmar. So, ICC has a role in preventing genocide, but it did not bring the charges against the Myanmar's military or other perpetrators who have committed genocide and crimes against humanity against the Rohingya people, but its rule has an impact on breaking genocide-causing cycles of violence. However, it is important to remember that it is undeniable that there is lack of consensus in selecting cases for investigations and prosecutions in the ICC. However, intervening in a country that is experiencing genocide can serve as an initial catalyst to encourage the state parties to actively combat this crime. This is one of the findings of this particular point in my research. Moving on to the second point, that is enhancing likelihood of genocide prosecution. The ICC deterrence is weak because of the absence of, its severe punishment and little likelihood of arrest of the suspects. There are some other reasons as well. For example, ICC does not have any police force to hunt down and arrest the suspect. It cannot proceed with a trial in absentia, which means it cannot conduct trials of the perpetrators unless they are present in the court. And it lacks resources to deter future offenses by making punishment an actual risk. So these are the challenges of the ICC to deter other perpetrators not to commit genocide. However, ICC's existence expands the risk of criminal trial juxtaposed with impunity. Because, if you look into its one of the impacts that the fear of change of regimes and of domestic trials afterwards can deter genocide. ICC is designed to localize international legal norms through principle of complementarity, which is really an important principle, and it prioritizes alternative domestic justice processes to secure accountability of international crimes. Moreover, ratifying Rome Statute promoted and prompted many state parties to strengthen their national legislations, national trials. For example, after ICC's involvement, Colombian government changed its plan to grant amnesty to a number of paramilitaries and instead proceeded with trials. So in my research, I've tried to explain that a combination of various ICC tools, for example, initiating investigations or issuing indictments, they potentially compel individuals who have committed or are considering committing crimes to reassess the probability of facing legal consequences. Now, moving on to another part of my research, that is ICC's genocide prosecution in the Al-Bashir case. I've tried to briefly explain what is the status of the Al-Bashir's case in the ICC at the moment. ICC's involvement in the Al-Bashir case is significant for two specific reasons. Firstly, it is the first case brought against a sitting head of state in the ICC with genocide, war crimes, and crimes against humanity. And secondly, it is the first case before the ICC that involves genocide counts. However, unfortunately, even after over 1 decade of issuing warrants, ICC has failed to arrest Al-Bashir due to, among others, lack of political will of the state, which is a result of its surplus constancy in international cooperation. So there is a lack of international cooperation from the state parties of the ICC, and that is one of the challenges of the ICC, and that could not successfully make Al-Bashir arrest in the ICC to conduct his trial. So the main point of my research is how can international cooperation be reinforced to prosecute genocide in Al-Bashir's case? One important thing is that characterizing alleged offenses as genocide prompts the question of invoking the Genocide Convention to obligate its state parties to assist ICC in arresting and surrendering Al-Bashir. So even if a state is not a party to the Rome Statute, if it is a party to the Genocide Convention, it has an obligation to help ICC to arrest Al-Bashir so that his genocide and other charges can be prosecuted. If we look into Article 6 of the Genocide Convention, it states that individuals caused of genocide must be sent to trial by an international penal tribunal. When Genocide Convention's contracting parties agrees to the jurisdiction of the under the Genocide Convention, it incurs a contingent obligation to collaborate the competent international tribunal as per the Bosnian genocide case. Particularly in the Bosnian genocide case, the ICJ determined that the ICTY qualifies as a competent international tribunal under this particular article of the Genocide Convention. Similarly, the ICC more closely resembles the treaty-based court the ICC Convention drafters envisioned. Therefore, this is the ending sentence of my presentation, that states that ratified both the Rome Statute and the Genocide Convention have a legal obligation to cooperate with the ICC regarding the proceedings against Al-Bashir for allegedly committing genocide to prevent and punish this crime. Thank you.
Thank you so much, Pizuar. I think it's really important to point out the fact that the existence of the International Criminal Court can actually mean that states can further comply with their obligations under the Genocide Convention, or even that state parties who aren't a party to the Genocide Convention can comply with it without even being a party because of the Rome Statute. So that's a great connection to make there. And that is the perfectly way thinking about the International Criminal Court to our final speaker on the webinar today. I'd like to introduce Dr. Hilly Moodrick-Even Khen, who is a Senior Lecturer of International Law at Ariel University in Israel and Chair of AU-CRSG. She has been teaching, researching, and publishing in the fields of international humanitarian law, international human rights law, and international criminal law since 2006. Her articles have been published in leading journals of international law and genocide studies. Her research focuses on the intersection between the legal and social aspects of genocide in contemporary contexts, such as the genocides of the Rohingya, the Yazidis, and the Uyghurs. Recently, she has been researching on the forcible transfer of children in Ukraine as a crime of genocide. Dr. Moodrick-Even Khen has published 2 books and 2 edited volumes, the latest of which is the co-edited volume titled The Syrian War Between Justice and Political Reality from 2020. Dr. Moodrick-Even Khen lectures extensively on her scholarly work, both in academia and the legal profession. And I'm delighted to turn over to Hilly to speak on international legal perspectives on the dormant prohibition of children's transfer in the Genocide Convention. Hilly, the floor is yours.
Thank you very much, Melanie, and thank you for giving me the opportunity to speak in this important event. And I know I have a short time, but I would still like to begin with a short reference that I would like to make here, a topical reference. And I'm saying that it is awful to think about how genocides can merge. Adam Muhammad Barima from Darfur was a survivor and refugee who fled to Israel in 2008. And he was murdered by Hamas genocidaires in the town of Sderot during the massacre of October 7th with his Jewish neighbors. His friends from the Darfurian community in Israel said that what Hamas had done is similar to the things that happened in Darfur. Hamas is Janjaweed, they said. So I'm calling upon the international community from here to respond to these horrible genocides so horribly connected. And now I would like to begin with my presentation. Okay. Okay, so yeah, just a minute. I'll do another share if you don't mind.
We can see that.
Yeah, I know, but I wanted to, sorry. It will take a minute. Okay, so I'm going to speak about the international legal perspectives on the dormant prohibition of children's transfer in the Genocide Convention, and the way that it was reflected in the ICC arrest warrants that were issued this year on 17th of March against President Putin and Ms. Lvova-Belova, who is Russia's Commissioner for Children's Rights. And the arrest warrants were in fact issued for not for a crime of genocide, but for war crimes, for a war crime of the deportation, the unlawful deportation, and the transfer of population, the transfer of children, though, from occupied territories of Ukraine to the Russian Federation. So I would like to suggest that this actually brings to mind the question of why these arrest warrants were not issued for the crime of genocide of the forcible transfer of children that is articulated by Article 6 of the ICC statute that in fact is taken verbatim from Article 2E of the Genocide Convention. And in this presentation, I will discuss the dormant prohibition on this forcible transfer of children in the Genocide Convention and its unique character as a provision that invokes both cultural and physical or biological genocide. And I will also discuss the difficulties in proving the special intent in the context of this provision in international courts and tribunals, and which may explain why it has become a dormant prohibition and has been rarely invoked as a crime of genocide. I'm not going to do this. Okay. So during the debate that took place in the drafting procedures of the Genocide Convention, the forcible transfer of children was finally accepted as a crime of genocide that accepted Lemkin's concept, Lemkin, who was mentioned earlier tonight. This concept that suggests that genocide is, of course, this coordinated plan of different actions that aim at the destruction of essential foundations of life of national groups with the aim of annihilating the groups themselves. But the question was whether this prohibition was accepted as a biological or cultural, as a form of biological or cultural genocide. If we look at the discussions in the ad hoc committee, for example, we understand that finally this prohibition was accepted as a form of biological genocide, but we can still see that the idea of cultural genocide does lie in the background of this prohibition, and perhaps it also somehow entered into this prohibition, although not explicitly, but implicitly. And what is further important is that we now know that the 21st member states of the Genocide Convention, and today 153 member states, actually accepted the gravity of the removal of children from their families and their uprooting from their environment. But then again, as I said before, the prohibition became dormant and was rarely applied by an international or domestic court. And the question is why? And I would like to suggest that it lies in the difficulty of proving the special intent that we as genocide scholars know that what qualifies as special intent is the conscious aiming to achieve a group's destruction. And the proof of genocidal intent, of this special intent, I would say in a nutshell, and maybe something lesser than a nutshell, is the intent that intent can be inferred from an existence of a genocidal plan or a genocidal state policy, which can be proven by resort to official statements, to directives, to anything that actually proves the state's policy. Now, the international courts and tribunals have suggested three interpretations of the special intent. The ICJ in Croatia versus Serbia suggested that only acts that were carried out with the intent of achieving the physical or biological destruction of the group, in whole or in part, can be considered genocidal. But the ICTY trial chamber in Krasniqi suggested an opposite and quite an original point of view, saying that accepting that the special intent is not limited to the physical or biological destruction of the group, because the group can be destroyed in other ways, such as with the transferring of children from the group to another, or by severing the bonds among its members. And the ICTY trial chamber in Krasniqi, I think, accepted as some kind of a midway approach, suggesting that while cultural genocide was in fact abrogated perhaps from the Genocide Convention, still the intent to culturally destroy the group can serve as evidence for the genocidal intent, which is a physical genocidal intent. Another problem with the special intent with relation to the Genocide Convention would refer to the distinction between intent and motive. We know that every act usually has both intent and motive, but criminal law usually disregards motive and focuses only on intent being the deliberate functioning to reach the end, manifests the intentionality of the conduct, and motive being the reasons or grounds for the end seeking. So what is behind the intent, you might say. Now, with the Genocide Convention, we had, in the ad hoc committee, we had arguments for including a motive and arguments against including a motive. The arguments for including the motive were that we should avoid conviction of genocide for acts perpetrated for non-genocidal motives. For example, a benevolent motive. I'm going to refer to it shortly right after this slide. And arguments against including a motive suggested that there were fears of exonerating people committing genocide on grounds that were not listed in Article 2 of the Genocide Convention, and therefore we should not include the motive. And the compromise was to add the words "as such" to the special intent clause. But this compromise has actually left us with some kind of a vague formulation of the mental element of the special intent. And as I said, I would like to say something about the benevolent motive. Perhaps we could say that we could see that colonial states' implicit suggestion during the discussions in the ad hoc committee was that we should include a motive because only acts of groups' destruction that were guided by hatred would be genocide. So when you have a benevolent motive, it shouldn't be considered as genocide. For example, the intent to assimilate indigenous peoples, for example, should not be considered as genocide. But the legal interpretation, I think, would suggest that the convention's purpose was to protect groups as entities, and therefore any destruction of a group would be prohibited by the convention and the motive would remain irrelevant. So to conclude, I am concluding with kind of a disappointing conclusion, I would say, with regards to the prohibition on the forcible transfer of children. Because we can see that in the ICC arrest warrants case now against Putin and Ms. Lvova-Belova, because of the difficulties of proving the special intent and notwithstanding evidence that actually exists to prove the forcible transfer of Ukrainian children, in the case of the forcible transfer, I'm just finishing, will not be pursued. And so we are left with this vicious circle where, because there are not enough precedents, that the prosecutor fears losing the case, but because he will not prosecute, it will not be possible to create precedents. Thank you for listening.
Thank you so much. That was fascinating and obviously a really current issue, and interesting to see this relationship between the specific crimes in genocide and the overall special intent and the challenges that lie ahead to seeing whether or not that will actually be prosecuted. That brings our webinar to a close. Thank you to all the speakers for, first of all, participating today and providing, honestly, such a varied and rich content for this webinar in talking about the legacy of the Genocide Convention at its 75th anniversary. And, thank you all to staying on time as well. This webinar will be made available on the IAGS YouTube channel. And so I encourage anyone to rewatch it or to share it with any colleagues who they think may be able to watch it. So once again, thank you to everyone who attended today, and thank you so much to our presenters for presenting their rich and varied research on the Genocide Convention.